And by the way, there's a case on the docket by name of O'Doyle Rules versus Friedberg. If you're here for that, that case was continued. All right, sorry.
Thank you. Hey, please, the court, counsel. Morning, members of the court. My name is Jervis Wise, and I represent Davis Mendez, the appellant in this case. And before I begin, I would like to reserve 5 minutes for rebuttal.
All right, you got it.
Thank you, Your Honor. And members of the court, unless the court would like me to address a specific issue first, I will go through the issues in the order they're set forth in the briefs. And the first issue is the trial court's denial of the motion to suppress in this case. And I recognize, as we did in the briefs, that this court generally defers to a trial court's findings of credibility and findings of fact. But this is one of those rare instances in which the record from the trial court simply does not provide competent, substantial evidence to support.
Let me ask you a question. You had an experienced trial judge, and she basically said, hey, this guy could be lying through his teeth. He made a lot of mistakes. He changed the report. He did this, he did that. But on anything relevant to the case, it doesn't really matter if this guy came out of the driveway at Shepherd's, whatever. She heard him speeding. He did a U-turn, and he was going to stop the guy and give him a speeding ticket. And he saw the car doing 45 and 50, 30 miles on, I think. So his intention is to give him a ticket, but as he walks up to the car, he smells the alcohol, turns into a DUI investigation, hence the arrest. So if the judge said, despite all these discrepancies, you can't take that away, I have to deny the motion to suppress. So with that in mind, tell me why we should reverse this case.
The reason, Your Honor, is because there is no evidence of the speeding and the basis for the stop other than this officer's testimony.
Okay, wait a second, time out, stop right there. And that normally is enough under the case law.
Normally, it's.
If he has credibility, the court said, I believe him. So keep going.
And the difference here, Your Honor, is that the court erred when it said credibility doesn't matter, because it did. Because in that situation, the only evidence supporting the basis for the stop was that officer's testimony. And the officer admitted to lying, essentially. He admitted to making a false
Now,
report.
I'm gonna guess you were the trial attorney below,
I was not, Your Honor.
somebody else?
Yes.
All these arguments were made to the jury.
They were made to the jury, yes.
The jury came back with the big G.
They did. Now, the jury, of course, couldn't decide the motion to suppress issue because that was decided by the trial.
Everything else.
But everything else they did. And
Yes.
yes, Your Honor, and we're not raising an issue of sufficiency of the evidence. We recognize, that we defer to the jury's finding on that regard. But the big issue, and what I think was also important about the trial court, is I think the trial court actually recognized that, yes, this officer was lying. And I would suggest she even was rethinking her ruling on the motion to suppress by that point.
Well, here's my other question. Normally, a case like this, you might try to implement a dismissal as a form of a sanction. But that wasn't done in this case.
It was not, and it was not requested, unfortunately, by
Okay.
the defense in the.
I might have a little more.
If we defer to, if we're to defer to the credibility determination of trial court, what would a reversal in this case look like? And would it be able to be avoided? Would a categorical rule that any time a witness has been found to have prevaricated, we can second guess the credibility determination of the court be ascertainable from reversal in this case?
I don't believe so, Your Honor, because I believe the precedent sets forth it'd be a very rare instance in which that could happen. And I would suggest this is one of those instances. And I believe the way the ruling would look would be that the finding of credibility was not supported by competent, substantial evidence in the record. And it would take
Because the officer lied.
because he lied about multiple things, and because the only testimony or the only evidence supporting his basis for the stop was his own testimony. If he had a radar reading, and if he actually had video showing what he said happened, it may be a different story. But
Well, he did have his experience with 1,000 or so stops where he had assessed this very problem.
he had that, and if it weren't for the multiple instances of false testimony he gave, I would say I wouldn't bring that issue. But I think the big difference is, unfortunately, this officer lied. He made a false report as well, and really gave.
I guess what the court was sort of saying is that because he was credible on the speed issue, the lie didn't really sway the court.
Essentially, now I think she actually probably rethought that by the time of trial, but that again goes back to the fact that I would suggest, Your Honor, that the trial court's ruling was not supported by the competent evidence because we saw so many instances in which this officer gave false
Right.
testimony.
It seems like it's a fulcrum point, you know, either you disregard the officer's testimony because it lacks credibility, or, I'm not saying you're conceding this, but you might be conceding that there was sufficient evidence because his testimony established reasonable suspicion for a traffic stop.
Well, I think, and Your Honor, you bring up a good point, that I think it kind of defies logic to say, well, we find him credible on this point, but not on this point. I think in this particular instance.
Is there some sort of critical mass amount of lies it takes for an appellate court to say to a trial court that substantial competence doesn't support credibility determination?
I think there must be, and I think this is an instance where that happened. I mean, and I know I chronicle it in the brief, but I could lay out the multiple instances in which he gave false testimony and even admitted it. And it wasn't just about the video. I would suggest, Your Honor, it was about, he says at one point that the car goes by him so fast it shakes. But then in another instance, he says, well, he was 100 to 200 yards away when he sees this. And that's not to mention the fact this is happening on Clearwater Beach at dinner time. I don't know that it's even possible for a car to drive by that quickly. But in any event, multiple instances where he gives that false testimony. And he gives inconsistent testimony about whether he sees the car pulling out of Shepherd's or not. It's just over and over again. The officer is saying things.
Well, to be honest, you had everything in your favor at the trial in this case that could have been, except the ruling from the judge. I mean, they didn't let the vomit in, that didn't get in, the guy throws up, the judge found the cop was lying about the time frame, hadn't reobserved him, was it 15 or 20 minutes after that happened?
Yes.
So that was kept out, and I assume that was in limine out, they didn't even hear about the mishap. They heard
Correct.
nothing about that, they only heard speeding, and the judge had the case law saying, you know, I either believe him or I don't believe him on that one issue. And you combine these other things that the judge probably knew about, but wasn't supposed to consider, and you have a DUI that they uphold. And I feel bad for you, but I don't know what else they could have done in this case.
Well, I think but for the trial court's ruling, it never would have made it to the jury, because I believe this would have been a dispositive motion. But for the officer's stop, there never would have been a case here at all. So,
Well, I feel your pain. I'm just saying, I don't know what else we can do except, like Judge Atkinson said, we'd have to announce a blanket rule that crossed the threshold. One lie too many, this is it. That's going to be hard for us to write that.
I understand, and again, I think, Your Honor, it goes back to the competent substantial evidence standard, and that's really a case-by-case
In cases
analysis.
in which and I don't recall whether you cited them, cases that an appellate court said there was not competent substantial evidence to substantiate or to support the credibility determination of the trial.
Not to that, in that regard, Your Honor, but there are cases we've cited where, in fact, a case from this court, the Shuttleworth case, states that ordinarily the court would defer. The Alt case from the Florida Supreme Court, which held that the appellate court may decide a question differently if the record does not support the trial court's finding. And I would suggest, I believe that was a credibility determination, Your Honor. But I can-
What case was that?
That was the Alt case, and that is,
Alt.
and admittedly, Your Honor, there are no cases that I believe are really on point on this issue, but that's the Alt case 866 Southern 2nd 674.
Right, so there's no case that says that the standard of review for credibility determination is competent substantial evidence, and here we either affirm because there's competence of substantial evidence or reverse, and in other words, the opinion would have to say, you know, this appellate court is reversing because the error was not disregarding the testimony of the witness.
In this situation, yes, finding that the witness was credible despite evidence that,
You cited all, and that stands for the proposition that the record has to clearly and irrefutably refute the trial court's ruling on deference to credibility. How are we going to do that? I'm going to say the guy lied multiple times on things that really weren't relevant to whether or not there's PC for the stop.
well, I believe based on the record of his repeated lies, and it does go back
How
to,
does that contradict the judge's ultimate ruling that it goes enough to go to the jury?
I believe, Your Honor, because the sole basis for that stop, again, was his testimony alone. And if there was something else aside from that,
That's incredible.
yes.
Okay, but how does that directly contradict the judge's ruling that on that one piece, it was credible, everything else incredible, but this one piece, they got you?
That's what I would suggest, Your Honor. The record does not support that finding, because
Okay,
why
that's-
on that?
that's for us to decide, in other words.
Yeah, of course, of course. And moving on to the second issue, which is the admission of the horizontal gaze and nystagmus testing. I recognize under the Meador case, there's an accepted line, once an officer is drug recognition expert certified, that testimony is generally admissible. But it doesn't always have to be that way. The important distinction, I believe, in this case is the state bears the burden of establishing that scientific evidence as being reliable and admissible. And in this particular case, I don't believe the state met that burden.
They didn't admit the results of the HGN to establish a presumption of impairment, just as part of the totality that, hey, the jury can consider this one piece of evidence because he was qualified to administer it. And they didn't admit it for proof of a BAC over a .04, let's say.
Not for that, at that level of evidence, but it was submitted.
But
Correct.
you can combine it with everything else, and just one more piece of evidence.
Yes, if it's reliable. And the problem is this isn't, and I believe in Meador, that's where the
Lie about
Supreme
his
Court.
training and background? We don't know. We
Well-
assume he's telling the truth.
We have to assume that, I assume. But we also then have to assume that he was testifying with credibility when he says
Well,
that.
obviously, you think he embellished everything.
Right, I do. I do. But even if we accept his testimony about the qualifications he had to testify to the HGN evidence, I don't believe the state met its burden of doing that. And essentially what he testified, the training he testified to having is what you would expect any traffic officer to have. Now, by the time of trial, he had obtained the DRE certification. And I would suggest if he had made a stop after that point, and once he'd obtained that certification, or even maybe when he began the training, he would have met the qualifications to testify to that. But at the time he administered HGN on Mr. Mendez, he didn't meet those qualifications. And I would suggest, again, Your Honor, this was the state's burden, and based on the limited testimony they presented from the officer, they didn't meet the burden of establishing admissibility of that evidence. And then turning to the final issue, which is the issue with regards to sentencing. And this court decided in the Alka Washmik case, I never know if I'm pronouncing that correctly, and said pretty clearly and definitively that the administration of a sentence is the duty of the sheriff's
Why
office.
isn't it a pertinent distinction that in that case, in the original sentencing, the trial court did not specifically direct that the defendant be precluded from the program?
I believe it goes back to the separation of powers. And if it's the sheriff's duty to administer the sentence and the court has no discretion over how the sheriff does that, or has no authority over how the sheriff does that, then it doesn't matter whether the trial court would try to.
Even if the administrative order itself creates an exception for the sentencing in which a trial court has stated overtly that this defendant is not to be admitted to the program, that's a dead letter because of the separation of powers under Alcoa.
Yes, Your Honor. And the reason is, and I would suggest, Your Honor, the administrative order really should be viewed as a nullity, because even the chief judge on the circuit doesn't have the authority to direct the sheriff how to administer a sentence.
What about, now, how far does that difference go? I mean, what if the Department of Corrections came up with a program where anybody who's, committed a first degree felony is allowed to serve it at home or just at liberty, and then check in with a parole probation officer every month?
And
Would
that,
would that be consistent with the statute that says, the sentencing statute that says you must serve it in prison, or?
I think in that situation, what would have to happen is the the executive branch or the legislative branch would have to step in and rectify that. Essentially, the governor removed.
But I mean, what power does a court have? I mean, the court sentences, right?
Exactly, yes.
What if they say, well, you know, the court sentences, a defendant to death, and then the Department of Corrections says, well, we take death to mean something different. We just mean, death in a more philosophical sense, and you have to, they come up with some other definition of death. And then you get to, live.
Well, and you know, I think a similar scenario has happened in some states where governors have commuted death sentences that were imposed by courts. And that was, that
No, I'm saying the agency, you know, can an agency just redefine what incarceration is?
no, they can't
Or death
redefine
is,
it, but,
or,
well,
you know,
and death, Your Honor, I would suggest is a.
it's a little bit less flexible.
Right.
My hypothetical, suffers from that, but incarceration, you know, is not that inflexible either, is it?
Well, when the sheriff's office in this situation has a program where the incarceration is to actually happen in someone's home with an ankle monitor, it could still meet the definition.
You're
And
down to 4 minutes and 10 seconds. You can keep going or you can save it.
that's,
You're in your rebuttal time.
okay.
I'm going to interrupt you.
Unless the, well, I would just finish answering the court's question by stating that in that situation, it's different from death because the sentence of incarceration can be and served under this program in someone's home, and that's what was happening. And if the court has no other questions, I will take my seat until the
I'll bump it up to 4 minutes.
Thank you.
Good morning, Your Honors. May it please the court. Lara Breslow with the Office of the Attorney General on behalf of the state of Florida. Taking the issues in order that my colleague addressed them, starting with the motion to suppress. This court acknowledged and counsel acknowledges this is a very rare and almost unreasonable request to have this court overturn the factual determinations made by the trial court. Just to address something that was raised in my colleague's argument, he said that the court said credibility didn't matter. That's not what the record shows. The court's order said that although there are issues with the officer's testimony, the written order said the officer's credibility is not at issue, even with the minor inconsistencies in the report. The court clearly considered the officer's credibility, clearly considered these inconsistencies, and still made a finding that his testimony regarding the traffic stop itself was still valid. There's no case law, as Judge Atkinson pointed out, supporting my colleague's view that an appellate court can just intervene and overturn a trial court's factual findings on credibility based on a certain critical mass of lies. More importantly, I would suggest to the court that the inconsistencies here, I know appellant refers to them as lies, but they are inconsistencies about ancillary things. They're not related to the traffic stop itself, other than the 20-minute observation and the blow, which was
Let's go fast forward to the third issue.
Yes, of course.
Why is the third issue not moot? Who cares? Shouldn't they have filed a cert or something to force themselves to be put in the alternative program? When the sheriff took a positive statement, the handbook turned it into a negative statement. If specifically authorized by, if not prohibited. So, and if not prohibited, was upheld by case law. And it is the executive realm of the sheriff, because you don't need to be authorized to do what you're gonna do anyway. So, the whole thing is like how many angels dance on the head of a pin to me. So why isn't it moved? The guy did the sentence, correct?
No, Your Honor, the
You
sentence
didn't do
was
the sentence?
stayed pending
Okay,
this
so it's
appeal.
not, because you could be deemed eligible, they could have another COVID outbreak, the sheriff wants to clear the jail, this guy could be put on electronic monitoring, let's say.
Correct. So there is no mootness because the sentence has been stayed pending the outcome of this appeal. Admittedly, there was not a 3800A filed with respect to the sentence. The appellant went straight to a direct appeal in this case. So we're not even looking at a motion to correct or challenge an illegal sentence in this case.
Can I ask you a question?
Of course.
Revocation,
Yes.
how does that help you?
So Ronan,
Does that put you in conflict with what we've already done in this, in that case?
no, Your Honor, Aquasma and Ronan really can be harmonized together because of the distinction that Judge Atkinson brought up, that The trial court in Alquazma was silent as to the placement of the inmate in that case, but the sheriff had the value of the administrative order allowing them to do that. In Roden, the trial court was silent and no such administrative order existed. And that was part of the crux of the first DCA's ruling, is that absent those two vehicles, either a court order or an administrative order, there was no mechanism by which the sheriff's office could release an inmate from the county.
Was that the Robin, the appellate panel's decision, the fact that there was, at the time of sentencing, there was no specific prohibition on participation in the program?
Yes, Your Honor, and I think it goes to the remainder of the Alquazma opinion, because in that situation, it's the separation of powers comes to an issue because an inmate was then placed in the care, custody, and control of the sheriff. The court intervened with how the sheriff's office treated and placed that inmate when it was previously silent.
Okay, so you're gonna thread the needle this way. So if the sentencing court says, this guy's gotta sit in a jail cell,
Yes,
that's not a violation of separation of powers.
correct, Your Honor.
What if they say, what if the sentencing court says, this guy is gonna sit in the jail cell and cannot participate in, therapeutic crochet classes?
Your
Is
Honor,
that a separation of powers?
yes, Your Honor, and there is case law,
Why?
because that's now
Why
dealing.
the distinction? Both of those were the sentencing court. The sentencing court said, you gotta sit in the jail cell, you can't go home and do with an ankle monitor. Well, but why can't, if that's true, it's not a separation, why can't the sentencing court say, you're not allowed to participate in any, you're not allowed to make license plates?
So in that instance, and there was a case about that where the inmate the trial court attempted to preclude recreational activities. That's a separation of powers because you're now looking at the direct treatment of an inmate in the custody, in that case in DOC, or the county jail. Versus here, when it happens at sentencing, the sheriff's office or DOC, if that was what we were dealing with, are not yet involved at the time of sentencing. Sentencing is purely with.
I know, okay, but let me make sure, understand my hypothetical, I understand you. So, just for the control factor here is that it's all, just take, whatever happens at sentencing, you're saying, because the distinction you're drawing, I think, in Alkawash is that the prohibition on participation in the program was not at sentencing by the sentencing judge, right?
Yes.
Right. But what, and then I asked, but that prohibition can be imposed at sentencing without violation of separation of powers under Alkawash. But you're conceding or saying that what the court can't do is impose other conditions. And why the distinction between this condition, condition A, which is you can't let this guy participate in your special program, in your home monitoring program. But the other, why the distinction between that and another at sentencing condition, which is, this guy is not allowed to participate in, the therapeutic macrame class.
So in that instance, you're looking at the treatment of an inmate versus a placement and the manner in which their incarceration is to be completed. And I think it's worth emphasizing, and this court noted in Alquazma, the purpose of the administrative order was to alleviate overcrowding issues at the Pinellas County Jail. It is not intended to create an alternative to incarceration. Moreover, the way that is structured when the jail hits this critical mass of 3,300 people, we start with pretrial detainees. It is a tiered system for release. First, beginning with pretrial detainees on certain misdemeanors, then violent misdemeanors, and then going through felonies. Those all have to be exhausted before this even comes into play for a sentenced inmate. And so it is, I think the distinction really matters that this is not an alternative to incarceration. That's not the design of this
So
administration.
let me get this straight. So a judge without violating the separation of powers can prohibit an alternative to incarceration at sentencing, but it would be a violation of separation of powers under Alkawash if a judge post-sentencing precludes an alternative to incarceration.
Yes,
However, at sentencing, a judge cannot, without violating separation of powers, direct other treatment of the inmate wherever he or she is residing.
That's correct, because that's going directly to the treatment of a housed inmate.
So we have more than one distinction going on, treatment versus alternative to sentencing, and we have at sentencing versus after sentencing.
Yes, Your Honor.
I'm just wondering whether we're confusing the distinctions and whether the distinctions are pertinent.
With respect to the at sentencing versus not, the sole mechanism by which the sheriff's office can release individuals under this program is the administrative order. Even though it is a separate constitutional officer, part of the executive branch, it does not
We're
inherently.
clear on that, that has
Right.
nothing to do with this here. Okay, go on, I'm sorry.
No, of course, Judge. And so for that, there is no other mechanism by which they can release other than the administrative order or a trial court's order. And that's what comes up to play in the Roden case from the first DCA, is that there was neither an administrative order or a court order. So in the instance of Aquasma, where the trial court was silent at sentencing, the sheriff is now under the purview of the administrative order. And so if the court intervenes after, it's essentially now shifted from the court and sentencing to the sheriff's care, custody, and control of the inmate. And the court cannot intervene when it is exercising its authority under the administrative order in that instance. But versus here, it's again important to remember that this administrative order says on its face that unless the sentencing court specifically prohibits such release. So the sheriff is still confined to the court's ruling at sentencing. We would agree it can't be modified after the fact where the trial court was silent.
Okay, well, I think I follow you, but then my question is, why can't I think I follow you insofar as, the post-sentencing, pre-sentencing as it pertains to this condition of confinement or alternatives to confinement. But why can't then at sentencing, a trial court direct other aspects of the defendant's treatment?
Because that's
Like programs that can, sorry, go ahead.
right, that's again going back to the manner of the incarceration versus the treatment during that incarceration. What activities an inmate may do in the custody of either DOC or the sheriff's office is separate from the manner by which they are incarcerated. The court is the sole body that can determine what the incarceration and what the sentence are. DOC and the sheriff's office are charged with the ministerial task of effectuating that sentence. Where an inmate is placed, whether they are in the actual facility, is distinct from what they get to do once they're there.
Okay, so another way to put it, it's a violation of separation of powers without regard to whether it's at sentencing or after, to direct the executive branch and how it treats an inmate, how it treats an inmate, in whatever incarcerative state that inmate is in. However, it's not a violation of separation of powers. No, but it's not a violation of separation of powers to add sentencing to dictate whether there can be alternatives to incarceration.
Correct, because at sentencing, it's determining the manner by which the individual is incarcerated, whether it is a home detention program, an electronic monitoring, or placement in physically either in the sheriff or DOC's custody.
So in other words, they're just treatment of the inmate is never within the purview of the court. But whether there is an incarcerated sentence or an alternative incarceration that sometimes is within the purview of the court without violation of separation of powers.
Yes, Your
Or
Honor.
only at sentencing.
At the time of sentencing, yes, that's correct.
You think that can be gleaned from Alkawash, or you get to rely on Roman II?
The court, and I understand that Your Honor was on the panel for Aliquaswa, but it does emphasize the fact that the trial court was silent. And so once the individual has been sentenced and is now in the care, custody, or control of DOC or the sheriff's office, we've now shifted which agency or what entity has power over that individual. And so in that instance, because the trial court was silent, the sheriff's office used the mechanism afforded in the administrative order. That is still separate from the situation in Roden where the sheriff unilaterally made the determination to release an inmate without, in the absence of an administrative order or a court order. And so Roden complements Alquazma because it emphasizes the ministerial task of implementing the sentence as issued by the court in the absence of any sort of alternative like we have in Alquazma, where the sheriff then had the ability to do this where the trial court was silent. And if there are no other questions regarding the third issue, I'll just briefly address the first two. Going back to the discussion earlier with appellant that there are no cases that set aside the trial court's factual determination. I would just emphasize that the cases cited in the brief challenging or claiming that the appellate court would have or the trial court does not have a superior vantage point to the appellate court. Those are instances in which the evidence is presented in the same manner to the appellate court that it is the trial court, such as a video, audio, those sort of recordings. Here, we are left with the black and white testimony of this officer. This court is not able to intervene or set that aside at this stage. With respect to the HGN, it's important to note that there is no bright line of how many prior instances in which an officer administered the test to determine whether or not they are sufficiently qualified to administer HGN. DRE has become the accepted baseline. It's not a requirement. Here, Officer Stiers did testify and the court acknowledged that he completed the A-RIDE, which is the Advanced Roadside Impairment Driving Enforcement, had multiple courses, both in the academy, post-academy, prior to becoming a DUI investigator that included practicing and training on HGN, and the fact that he administered it approximately 300 to 500 times prior to this arrest. That is sufficient evidence for the court to determine that he had the qualifications to testify to it. And even if that is admitted an error, it is a harmless error considering the remaining evidence that was admitted. The jury was presented with a video of appellant's performance on the field sobriety exercises, the testimony of both Officer Stiers and Officer Rodriguez about the signs of indicators of impairment, such as the odor of alcohol, bloodshot watery eyes, unsteady gait. He was fumbling with his driver's license. The patrol car video showing appellant nodding off on the way to the jail, and most importantly, the appellant's own admissions that he consumed multiple beers prior to getting behind the wheel of the vehicle, and that he he disagreed with the officer's assessment of how drunk he was. The jury had video and testimony, sufficient video and testimonial evidence that even if HGN was admitted in error, it is a harmless error. And if the court has no other questions, the state would rest on the brief and request this court affirm the conviction and maintain the sentence as issued by the court. Thank you so much.
Mr. Weiss, you get 4 minutes.
Thank you, Your Honor. Members of the court, going back to the third issue, I disagree that the trial court is the sole body that is to direct where an inmate is to serve a sentence. And sentencing courts in Florida, with regards to DOC sentences, have recognized that for decades. There have been many times, and I'm sure the members of the court have probably seen, when inmates ask for a certain program, they ask to be housed in a certain place, and the trial court says, I have no authority over the Department of Corrections. And that's because of the separation of powers doctrine. And that's what ACWA was.
I think, yeah, you can say, well, I don't want to be at Sewanee Correctional Institution versus, Rayford or something. That's different than what I think the state is saying, which is the distinction between actual incarceration and alternative incarceration, that the trial court does, without violation of the separation of powers, have that authority at sentencing.
And I think a better example, Your Honor, that may be more analogous to the issue here would be a work release program that the DOC, it's something the DOC has administered for many, many years.
Is there cases in which the trial court has, that's been deemed to, the trial court tried to direct that sentencing that a work release program would be off limits and was shut down because that was separation of powers?
Not that I'm aware of, Your Honor, and I believe that's because trial courts recognize they have no authority to tell the DOC an inmate can or cannot participate in a work release program. And that's essentially the same, as a practical matter, that's the same kind of program the sheriff's office was administering here. The inmates weren't being released to work, but they were serving their sentences at home. And the trial court attempted to draw a distinction between the DOC's authority and the sheriff's authority. But the problem is they're both executive branch members, and the separation of powers does not apply to DOC, but not the sheriff. It applies.
How is it inconsistent with the sheriff's standard operating procedures? The sheriff says, if not prohibited by the trial court. They're giving deference to the trial court. The trial court is not trying to override the sheriff and make them do something. They're making themselves participate or not participate.
Well, I believe the sheriff has the authority to do that. And if the
That's
sheriff,
what they did. The sheriff is respecting the trial court's order. It says in their manual, if not prohibited.
but it's my understanding that manual is based on the administrative order, which gives the trial court the authority to direct.
You didn't raise it in non-delegation issues, separation of powers, saying, that's a violation of separation of powers because the sheriff was, or whoever, who does the administrative order? What's the?
I believe it was the chief judge of the sixth.
So, I guess it would be non-delegation because the order itself would be from the judicial branch.
Correct. And
Does that complicate things a little bit too? That's from the judicial branch and the judicial branch.
again, I don't think it complicates matters because I don't think the court had the authority to enter that administrative order at all, because it's really up to the sheriff to determine. Now, the sheriff can say, if a court doesn't want me to, I won't, but it's his decision to make. In this particular instance, the trial court tried to.
You go the other way, right? The trial, the chief judge could say, you know what? I don't like all these folks rotting in the county jail, it's terrible, let them all out, and then the sheriff could disregard that too.
Yes, I believe so, because I don't believe that.
20 seconds to wrap it up.
And to answer your honor, the reason for that is the court doesn't have the authority to enter an order in that regard in either direction. It's the sheriff's office's. Thank you.
All right, thank you. We'll argue. Have a nice day.